So the Supreme Court just handed down an 8-1 emergency ruling that completely changes everything we thought we knew about Second Amendment enforcement in this country. What happened in the last 48 hours will determine whether states can actually draw constitutional lines against federal gun regulations they believe violate citizen rights. Hit that subscribe button right now, because what I'm about to break down affects every single gun owner in America, and the mainstream media is barely scratching the surface of what this ruling actually means. The 8-1 vote that shocked legal experts. Here's what makes this 8-1 vote absolutely unprecedented. When you look at Supreme Court decisions on Second Amendment cases over the last 15 years, only 19% have resulted in this level of consensus. Most split 5-4 or 6-3 along completely predictable ideological lines. But this time, justices appointed by both Democratic and Republican presidents joined together in the majority, and that alone should tell you something massive just shifted in constitutional interpretation. Justice Sotomayor stood alone in dissent, and her 22-page opinion cites 63 different precedents, making it one of the most extensively documented solo dissents we've seen this entire term. She argues the majority's framework opens dangerous doors that extend far beyond firearms into areas of federal-state relations nobody has fully considered yet. But here's what really matters about the emergency posture of this case. The Supreme Court grants emergency relief in fewer than 12% of requests. They're extremely selective about when they intervene before a case fully develops through the lower courts. Yet here they acted within 96 hours of receiving final briefs. That speed tells you everything about how seriously they're taking the constitutional questions at stake. The legal community is still processing what this means. In the 72 hours since the ruling dropped, over 340 constitutional law professors have published responses, and they're split almost exactly down the middle on whether the court made the right call. What nobody disputes is that this emergency order just rewrote the playbook for how Second Amendment battles will be fought in federal courts going forward. What the ruling actually says, the 4 key holdings. Let me break down exactly what the Supreme Court decided, because the actual holdings are more nuanced than any headline suggests. The court established 4 distinct legal principles that will govern every Second Amendment preservation case from this point forward. First, they confirmed that states possess what's called residual sovereignty over firearms regulations within their borders. This doesn't mean states can ignore federal law, but it does mean they have constitutional authority to establish their own interpretation of Second Amendment protections that may be more expansive than current federal standards. The court cited 11 different historical examples from the founding era, showing states maintained independent authority over arms regulations even after ratifying the Constitution. Second, the court drew a critical distinction between passive non-cooperation and active obstruction. States can refuse to use their own resources, personnel, and funding to enforce federal firearms regulations they view as unconstitutional. That's protected under what legal scholars call the anti-commandeering doctrine. But states cannot actively interfere with federal agents conducting their own enforcement operations. The court spent 18 pages explaining exactly where that line exists, and it's more favorable to state authority than most legal experts predicted. Third, and this is where it gets really interesting, the court ruled that states can create financial disincentives for state employees who voluntarily choose to cooperate with federal enforcement outside their official duties. This was the most surprising holding, because lower courts had consistently struck down these penalty provisions. The Supreme Court distinguished between prohibited commandeering and permissible structuring of state employment conditions. As long as state officers aren't federally deputized, states can regulate their conduct regarding federal cooperation. Fourth, the court established a new test for evaluating when state laws cross from legitimate sovereignty protection into unconstitutional interference. They created what they're calling the operational interference standard, which asks whether a state law materially prevents federal officers from executing their statutory duties using federal resources. If federal agents can still conduct investigations, make arrests, and pursue prosecutions using their own personnel and funding, then state non-cooperation doesn't rise to the level of constitutional violation. The historical precedents everyone missed. Here's the part almost nobody in the media is explaining correctly. This ruling didn't come out of nowhere. The Supreme Court has been building toward this framework for over 30 years through cases that had nothing to do with guns. The foundation started in 1992 with New York versus United States, a case about radioactive waste disposal. The court ruled 6-3 that Congress cannot compel states to enact or administer federal regulatory programs. Justice O'Connor wrote that the Constitution has never been understood to confer upon Congress the ability to require states to govern according to Congress's instructions. That established the anti-commandeering doctrine, but most people thought it only applied to extremely limited circumstances. Then in 1997, the court decided Prince versus United States, which actually did involve firearms. The Brady Act required state law enforcement officers to conduct background checks on handgun purchasers. The Supreme Court struck down that requirement, with Justice Scalia writing that the federal government may neither issue directives requiring states to address particular problems, nor command state officers to administer or enforce federal regulatory programs. That ruling established that states cannot be forced to enforce federal gun laws, but it left open questions about what states could affirmatively do to prevent cooperation. The doctrine expanded significantly in 2012 with National Federation of Independent Business versus Sebelius, the Obamacare case. While most attention focused on the individual mandate, the court also ruled that Congress couldn't coerce states into expanding Medicaid by threatening to withhold all Medicaid funding. Chief Justice Roberts wrote that the financial inducement offered by Congress might well be coercion, establishing that federal pressure on states has constitutional limits even when using funding rather than direct commands. Then came Murphy versus NCAA in 2018, which involved sports gambling. New Jersey passed a law repealing its prohibition on sports betting, and the federal government argued this violated a federal law prohibiting states from authorizing sports gambling. The court ruled 6-3 that the anti-commandeering doctrine applies not just to forcing states to act, but also to preventing states from repealing their own laws. Justice Alito wrote that the anti-commandeering doctrine may sound arcane, but it is simply the expression of a fundamental structural decision incorporated into the Constitution, the decision to withhold from Congress the power to issue orders directly to the states. What's remarkable is that since Murphy, 19 states have passed laws declining to enforce various federal regulations on immigration, environmental standards, and healthcare mandates. Not a single one of those laws has been struck down as categorically unconstitutional. But when states tried the same approach with firearms regulations, federal courts treated them completely differently. That inconsistency is exactly what this new Supreme Court ruling addresses. The court's emergency order cites Murphy 7 times and quotes Prince 12 times, making absolutely clear they're applying established anti-commandeering principles to Second Amendment preservation laws. The question isn't whether states have this authority. The question is only how far that authority extends and where the constitutional boundaries lie. So it's the enforcement mechanisms that changed everything. Now let me explain the specific mechanisms in these Second Amendment preservation laws that triggered this entire constitutional showdown, because understanding these 4 enforcement tools is critical to grasping what the Supreme Court just decided. First, these laws establish what legal scholars call a state constitutional floor. The state declares its own interpretation of the Second Amendment that provides more protection than current federal interpretations require. Texas's version, for example, explicitly identifies 28 categories of federal firearms regulations as unconstitutional under state law, including serialization requirements for personally manufactured firearms, certain prohibition on interstate sales, and specific licensing schemes for manufacturers. These provisions don't invalidate federal law, but they establish the state's constitutional position and create the foundation for the other enforcement mechanisms. Second, preservation laws sever cooperative federalism relationships. For decades, federal agencies have relied on state and local law enforcement to assist with federal firearms investigations, share database access, provide personnel for joint task forces, and use state facilities for federal operations. These cooperative arrangements saved the federal government an estimated $4.2 billion annually, according to a 2023 Government Accountability Office report. Second Amendment preservation laws terminate these voluntary cooperation agreements, forcing federal agencies to operate independently using only their own resources. Third, these laws create significant financial consequences that deter state officials from choosing to cooperate outside official channels. Texas's law imposes civil liability of $50,000 per violation on any state or local official who substantially participates in federal firearms enforcement. Since passage, 243 Texas law enforcement officers have formally withdrawn from federal joint task forces specifically to avoid this liability exposure. The financial penalties apply even when cooperation occurs during off-duty hours, making it personally risky risky for any state employee to assist federal operations in any capacity. Fourth, and this is the mechanism that generated the most litigation, these laws establish private enforcement through citizen lawsuits. Any Texas citizen whose Second Amendment rights are allegedly violated by state cooperation with federal enforcement can sue the state officials involved and recover attorneys' fees plus statutory damages. This is structurally identical to the enforcement mechanism Texas used in its abortion law SB 8, which the Supreme Court allowed to proceed despite serious constitutional concerns. The citizen enforcement provision effectively deputizes the entire population to monitor and police state employee conduct. The Supreme Court's emergency ruling addresses each of these mechanisms separately and establishes different constitutional standards for evaluating them. The first two mechanisms, establishing state constitutional positions and terminating cooperative agreements, receive the strongest protection under anti-commandeering principles. The court ruled these fall squarely within state sovereignty and cannot be prohibited by federal courts absent actual interference with federal operations. The financial penalty provisions occupy a middle ground. The court held that states can structure employment conditions and create liability for official conduct during work hours, but suggested that penalties extending to purely private off-duty conduct might be problematic. They remanded this issue for further factual development about how the penalties actually operate in practice. The citizen enforcement mechanism received the most skeptical treatment. The court noted this creates potential conflicts with federal supremacy by allowing private lawsuits to second-guess the constitutionality of federal enforcement actions. However, rather than striking it down entirely, they instructed lower courts to examine whether the lawsuits actually interfere with federal operations or merely provide state-level remedies for state employees exceeding their authority. The DOJ position that nobody saw coming. Nobody. Here's where this case took a turn that shocked everyone following Second Amendment litigation. When the Biden administration filed the original lawsuit in March 2023, they dedicated 9 attorneys from the Civil Rights Division and filed an 89-page complaint arguing that Texas's entire Second Amendment preservation law was unconstitutional from top to bottom. Their brief demanded complete injunctive relief, sought $3.7 million in litigation costs, and requested that courts prohibit any future attempts by Texas to limit federal firearms enforcement within state borders. The Biden DOJ's position was absolute. They argued that any state law limiting cooperation with federal firearms enforcement violated the Supremacy Clause, interfered with federal sovereign interests, and unconstitutionally discriminated against federal operations. They cited 41 different precedents and constructed a 200-page appendix of supporting materials. Their goal was clearly to obtain a sweeping ruling that would invalidate Second Amendment preservation laws in all 18 states that had enacted them. When the Trump administration took office in January 2025, this case was pending before the Supreme Court on emergency appeal from the Fifth Circuit. The incoming DOJ requested 4 separate extensions, totaling 117 days before filing their position, an extraordinarily long delay that had Second Amendment advocates hoping for a complete reversal of the government's stance. When the Trump DOJ brief finally arrived in May 2025, it surprised absolutely everyone by taking what they called a constitutionally grounded middle position. They conceded that substantial portions of Texas's law are protected under anti-commandeering doctrine and that the Biden administration had overreached in challenging the entire statute. Specifically, they identified 11 sections of Texas's 16-section law as constitutionally permissible and withdrew opposition to those provisions entirely. However, the Trump DOJ maintained that 5 specific provisions go too far. They argued the citizen lawsuit mechanism allowing private parties to sue state officials for alleged Second Amendment violations creates an improper interference with federal enforcement discretion. They also challenged provisions that impose criminal penalties on federal agents who enforce certain regulations without state permission, calling these an unconstitutional intrusion on federal sovereign immunity. Most significantly, the Trump DOJ withdrew the Biden administration's request for $3.7 million in litigation costs and offered to dramatically narrow the preliminary injunction to block only the 5 disputed provisions while allowing the other 11 sections to take effect immediately. They filed a 34-page supplemental brief explaining that their position better reflects constitutional principles of federalism and state sovereignty while still protecting essential federal interests. This position shift created chaos in the litigation. Texas argued the federal government's concessions proved the preliminary injunction was overbroad from the beginning and should be vacated entirely. The Biden administration attorneys who originally filed the case submitted a formal objection to DOJ leadership, arguing the position change undermines institutional credibility, and circuit judges who had ruled against Texas based on the Biden DOJ's arguments publicly questioned whether their decisions remain valid given the government's changed position. The Circuit Court contradiction that broke the case. The Fifth Circuit Court of Appeals issued a 94-page opinion in December 2024 that contained what three constitutional law professors called the most glaring internal inconsistency in a published circuit court opinion in the last decade. Understanding this contradiction is essential to grasping why the Supreme Court intervened with emergency relief. On page 47, the three-judge panel explicitly acknowledged that Texas's prohibition on state officer participation in federal firearms enforcement is structurally identical to sanctuary city policies that have been upheld in the 2nd, 3rd, 7th, and 9th circuits. The court spent 14 pages analyzing why the legal mechanism of non-cooperation falls within protected state sovereignty under Prince and Murphy. They even cited favorable language from those sanctuary city decisions, noting that states possess substantial sovereign interests in refusing to cooperate with federal enforcement of laws they believe exceed constitutional boundaries. But then, starting on page 61, the exact same judges performed a complete reversal. They ruled that Texas's law is unconstitutional specifically because its purpose is to protect Second Amendment rights that Texas believes the federal government is violating. The court created what they called a purpose-based exception to anti-commandeering doctrine, holding that states can refuse cooperation for neutral administrative reasons like resource allocation or community relations, but cannot refuse cooperation when motivated by constitutional objections to federal policy. This purpose-based analysis created an absurd rule. States must pretend they're not defending constitutional principles, even when that's obviously their actual motivation. The Fifth Circuit distinguished immigration sanctuary policies by noting those laws cite budget constraints and community trust as justifications in their text, not explicit constitutional objections. Effectively, the court ruled that states can exercise anti-commandeering authority only if they disguise their true constitutional concerns behind neutral policy language. Texas's petition to the Supreme Court absolutely eviscerated this reasoning by pointing out the absurdity. They noted that Texas's law references the Second Amendment 23 times in its preamble as explanation for why the state is exercising its sovereignty, and the Fifth Circuit cited this transparency as evidence of improper purpose. Meanwhile, California's sanctuary policies contain explicit language about protecting immigrant constitutional rights and resisting federal overreach, yet no court has ever suggested this constitutional purpose invalidates those laws. The contradiction gets even worse. The Fifth Circuit praised Texas for including detailed legislative findings explaining its constitutional concerns, calling this evidence of careful deliberation. Then the court turned around and used those exact same findings as proof the law was motivated by improper animus toward federal enforcement. Texas literally couldn't win. If they provided no explanation, courts would call the law arbitrary. When they provided detailed constitutional reasoning, courts called it evidence of improper purpose. 4 different amicus briefs filed by constitutional scholars called this viewpoint discrimination against state laws protecting disfavored constitutional rights. They pointed out that 47 states include constitutional reasoning in legislative preambles for various laws, and no court has ever suggested this invalidates the legislation. The Fifth Circuit essentially created a rule where states can exercise anti-commandeering authority for any reason except defending constitutional rights, which is precisely when that authority matters most. The Supreme Court's emergency order directly addresses this contradiction. In their brief per curiam explanation, they state that anti-commandeering doctrine does not contain purpose-based exceptions that turn on whether states invoke constitutional justifications. They cite Murphy's holding that states retain sovereignty to make policy choices even when those choices conflict with federal preferences, and nothing in that principle depends on why states make those choices. This holding alone will reshape dozens of pending cases involving state resistance to federal policies across multiple issue areas. Tudur, the 18 states waiting for this exact ruling. Texas isn't fighting this battle alone, and the implications extend far beyond one state's Second Amendment preservation law. 18 states have either enacted similar laws or have legislation pending right now, representing a combined population of 147 million Americans. Every single one of them paused implementation efforts while waiting for the Supreme Court's decision in this case. Florida passed the Second Amendment Sanctuary State Act in 2023, which has been preliminarily enjoined in federal court since April 2024. The injunction blocks all provisions, including basic non-cooperation language that the Supreme Court's new ruling clearly protects. Based on this emergency order, Florida's Attorney General has already filed a motion to dissolve the injunction, and legal experts expect the district court to narrow it significantly within 60 days. Arizona enacted the Firearms Freedom and Anti-Commandeering Act in 2024, currently facing challenge in the Ninth Circuit. Arizona's law goes further than Texas's by including criminal misdemeanor penalties for any person who attempts to enforce federal firearms regulations the state has declared unconstitutional. That criminal provision remains constitutionally suspect even under the Supreme Court's new framework, but the core non-cooperation provisions should survive. Montana's law contains even stronger provisions than Texas's, including a $75,000 civil penalty per violation and a state-funded legal defense fund that has already accumulated $4.3 million to defend citizens who sue state officials for cooperation. Montana appropriates $500,000 annually specifically for litigation defending the preservation law itself, showing how seriously these states take the constitutional fight. The financial implications are staggering. Federal law enforcement agencies conducted 12,847 firearms-related investigations across these 18 states in 2024, with 78% involving some level of state or local cooperation. If all 18 preservation laws became fully operational under the Supreme Court's new framework, the ATF estimates their investigation capacity in those jurisdictions would drop by 64%, forcing them to reallocate 520 federal agents from other regions or hire additional personnel at a cost of approximately $89 million annually. But here's what makes this even more significant. Every one of these states has been watching to see whether the Supreme Court would uphold state sovereignty principles or side with expansive federal enforcement authority. The 8-1 vote with detailed framework guidance gives these states exactly the roadmap they need to structure their laws to survive constitutional scrutiny. Within 48 hours of the Supreme Court's emergency order, attorneys general from 14 states issued a joint statement declaring their intent to move forward with implementation of Second Amendment preservation laws using the court's guidance. 3 additional states that had tabled legislation announced they're reviving those bills with modifications to comply with the operational interference standard the court established. The implications that extend far beyond firearms. Now here's the part that should concern everyone regardless of where you stand on gun rights, because the constitutional principles the Supreme Court just defined apply to every policy area where states disagree with federal enforcement priorities. Right now, 26 states have laws limiting cooperation with federal immigration enforcement using the exact same anti-commandeering principles. 21 states have refused to assist with certain DEA marijuana investigations despite continued federal prohibition. 14 states have declined to enforce specific EPA regulations they view as exceeding constitutional authority. And 9 states have passed laws limiting participation in federal healthcare mandate enforcement. Every single one of these laws relies on the anti-commandeering doctrine the Supreme Court just clarified and strengthened. The framework established in this emergency order will govern all of those disputes going forward. If states can refuse cooperation with federal firearms enforcement based on constitutional objections, they can apply the same principle to immigration enforcement, environmental regulations, healthcare mandates, or any other federal program they believe exceeds constitutional bounds. The implications reach into territory most people haven't even considered yet. Could blue states refuse to cooperate with federal enforcement of potential national abortion restrictions if Congress passes such legislation? Could red states decline to assist with federal enforcement of environmental regulations they view as violating principles of federalism? The Supreme Court's operational interference standard provides a framework for answering these questions, but it opens doors in both ideological directions. The financial consequences alone are massive. The Congressional Budget Office estimated in their 2024 report that federal law enforcement relies on state and local cooperation for activities valued at $11.3 billion annually across all policy areas. If even 30% of states exercise broad non-cooperation rights across multiple federal programs, the federal government would need to hire approximately 22,000 additional federal agents at an annual cost of $3.4 billion just to maintain current enforcement levels. This case, framed as a Second Amendment battle, actually addresses one of the most fundamental questions in American constitutional structure. Where does federal authority end and state sovereignty begin? The Supreme Court's 8-1 emergency ruling provides the clearest answer to that question we've seen in over 30 years. What happens next in the lower courts? The Supreme Court's emergency order remands this case to the Federal District Court in Houston with specific instructions that will completely reshape how litigation proceeds. The blanket preliminary injunction that blocked Texas's entire preservation law will almost certainly be modified within the next 90 days based on the framework the Supreme Court established. The Trump DOJ has already indicated they'll file a motion to narrow the injunction within 21 days of the remand becoming effective. Under standard civil procedure rules, Texas will have 28 days to respond, with a hearing typically scheduled 45 to 60 days after that. The district judge assigned to this case, Judge Andrew Hanen, has handled 34 major constitutional challenges during his tenure, and his rulings tend to favor state sovereignty positions in federalism disputes. Based on typical district court timelines for preliminary injunction modifications, we're looking at a new order sometime in late September or early October 2025 that will allow substantial portions of Texas's law to take effect while keeping only the most problematic provisions enjoined. That narrowed injunction will then set the template for how all 18 state preservation laws get evaluated going forward. The factual record development phase will require both sides to produce actual evidence about how these laws operate rather than speculating about hypothetical harms. The federal government will need to document specific instances where state non-cooperation prevented federal investigations or prosecutions, given that most preservation laws have been blocked by preliminary injunctions and never actually took effect. Producing that evidence may prove extremely difficult. Discovery in this phase typically takes 5 to 7 months, meaning we could see a full trial on the merits scheduled for mid-2026 with a final district court decision by late 2026. That decision will certainly be appealed regardless of outcome, putting this back before the Fifth Circuit in early 2027 and potentially before the Supreme Court again for full merits review in the 2027-2028 term. That's exactly where this critical Second Amendment preservation fight stands right now after the Supreme Court's 8-1 emergency ruling. As this case develops through every stage of litigation, I'll be breaking down each development as it happens with the same level of detailed analysis you just got. If you want to stay ahead of these updates and understand how this reshapes not just gun rights, but the entire structure of American federalism, smash that subscribe button right now and drop a comment below telling me whether you think states should have this level of authority to resist federal enforcement they view as unconstitutional.